Hopefully it's a nice, slow, easy Friday for you guys. Not too busy. We're wrapping up the summer, so hopefully you're squeezing in as much as you can before summer is over and then the snow comes. Josh, I know. Josh, that sucks. It sucks. Okay, I'm just gonna say one thing and move on. I love justice, and now I'm done with that. We're gonna watch 2 new judges today. I don't know if anything crazy happens. I just don't. I have no idea. But the first one I got just because everybody is pretty. I can't help it. And then the next one was, I think he's a new judge. We might have shown him. I might have shown him once or twice before. Now that I think about it, so not a new judge, but exclusive to this channel. That's for sure. But so it's possible that I took a tiny clip from the first judges and made a video out of it, but I just really, gosh, don't remember. I don't even know. I don't think I played that one clip during a live stream. But this is the bigger docket. This is from a little bit ago. But, okay. Let's see. Where's my Twitch? I'll figure it out.
Against or tamper with any witness to or victim of the acts you are charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or consume alcohol or drugs. No driving without a valid license, insurance, and registration. No possession or consumption of marijuana except with a valid medical marijuana card. The mandatory protection order is a condition of bond. The recommendation in this case is a personal recognizance bond with no supervision. Ms. Pearson, your argument?
Your Honor, we have no objections to the recommendation in this case.
Okay, Ms. Bell, if I follow the recommendation, anything further?
No.
Okay. All right, Ms. Bilger, I'm going to set your bond at $1,500 personal recognizance with no supervision. Your next court date is August 1st at 8:30 in the morning in Division 303. So I've given you a personal recognizance bond, meaning that you don't have to post anything in order to be released. But if you fail to appear at a subsequent court date, that $1,500 could enter as a judgment against you. Do you understand that, ma'am?
Yes, I understand.
All right, thank you. The court will call 2025 CR 762 George Carter.
Carter.
And I'll waive reading and advisement for Mr. Carter.
Thank you. Mr. Carter, can you hear the court?
My button's not on, sorry.
Yes, ma'am.
All right. There will be a mandatory protection order that enters in your case. The provisions of that mandatory protection order are that you shall not possess or control a firearm or other weapon. You shall not possess or consume alcohol or drugs. No possession or consumption of marijuana except with a valid medical marijuana card. Obey all active mandatory protection orders and restraining orders issued against you. The mandatory protection order is also a condition of bond. The recommendation for bond is an enhanced bond with enhanced cautionary bond. Ms. Pearson.
Your Honor, we would again agree with the recommendations in this case. Based on the charge, we would also be requesting GPS monitoring, considering the allegations indicate that he did leave the state.
Ms. Bell?
Judge, I'm just asking the court to set a reasonable bond given the Class 6 felony. He does have the parole holding him, so.
All right, the court's going to follow the recommendation. I'll set bond in the amount of $2,000 cash or surety. I'm going to make that with enhanced supervision. Sir, your next court date is July 31st at 8:15 a.m. in Division 403. Thank you.
Excuse me. Hello?
Sir, I would advise you have an attorney representing you right now. Please don't make any statements, okay, sir?
No, I wasn't making a statement. I was on, who is the, what is it, the little,
The bond setup?
no, the thing with the paper and saying, like, who's my victim? Is basically what I'm saying. I ain't did nothing to that.
Want to
Sir,
be?
I didn't enter any protection orders regarding a victim.
Well, maybe you should have, Judge.
Okay.
You want to be soft set? He's trying so hard. No, he's not trying so hard. He's done. But who's my victim?
All right, thank you, sir.
All right.
All right, the court will call
Bill.
2025
Hi,
M
Bill.
1105
Hi, Bill.
Julie Durant.
Julie Grant. Give you a bond or what? Yeah.
Hello,
Miss Durant, can you hear the court, ma'am?
I sure can.
Miss Bell, waiving advisement?
It's
Okay. All right, ma'am, there will be a mandatory protection order that enters in this case. The provisions of that protection order require that you shall not harass, molest, or intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim may likely to be found. And you shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or consume alcohol or drugs. No possession or consumption of marijuana except with a valid medical marijuana card. The mandatory protection order is a condition of bond. The recommendation in this case is a personal recognizance bond with no supervision. Ms. Pearson, your recommendation.
Your Honor, we would agree with the recommendation, but we would request basic supervision based on her history of failing to appear in court.
Ms. Bell,
Okay.
if I follow the recommendation, is there anything further? All right, I am going to just follow the recommendation in this case. Bond is going to be set at $1,500 personal recognizance bond. I'm not going to order any supervision. Ma'am, as to this case, you are released as a personal recognizance bond I've issued in your case. However, you may have some municipal warrants holding you, but as to this case, you are released. Your next court date is August 1st at 8:30 in the morning in Division 303.
Yeah, on the municipal warrant.
Don't, ma'am, I'm gonna stop you right there.
okay.
I am not the municipal court judge. I don't
Okay,
want
I
you to
gotcha.
say anything, okay? I have no jurisdiction to modify your municipal court holds or anything like that, okay?
No problem.
All right, thank you, ma'am.
Thank you.
All right, the court will call 2025 M1110 Natalie Mueller.
I'll wait for the reading and advisement.
All right, thank you. Ms. Mueller, can you hear the court, ma'am?
Yes.
Okay. All right. The court found probable cause in this matter for an alleged act of domestic violence. There will be a mandatory protection order that enters in this case. The provisions of that protection order requires that you shall not harass, molest, or intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or control a firearm or other weapon. You shall not possess or consume alcohol or drugs. You shall not possess or purchase any ammunition. You shall relinquish for the duration of the order any firearm or ammunition in your immediate possession or control or subject to your immediate possession or control, and do so within 24 hours. You will also be required to complete an affidavit and file it along with proof of relinquishment with the court within 7 business days. That affidavit that you need to fill out and file with the court was provided to you along with the paperwork pertaining to the protection order. You're also ordered to obey any and all active protection orders and restraining orders issued against you. No possession or consumption of marijuana except with a valid medical marijuana card. The mandatory protection order is a condition of your bond. The recommendation in this case is for a personal recognizance bond with no supervision. Ms. Pearson.
And Your Honor, we would be asking for some level of supervision in this case based on the underlying facts and the criminal history here.
Actually, let me take a look.
I think that there was a
Was basic.
recommendation for some supervision.
Yeah, you're
based
right, Ms. Pearson. I apologize. The recommendation was for a personal recognizance bond with basic supervision. All right, Ms. Bell?
Judge, I am asking the court to follow the recommendation in this case. As I'm sure the court is aware, there's a co-defendant slash also the alleged victim, also on advisements today. He has significant community ties and has lived in Pueblo his entire life. All of his family lives here. Miss Mueller moved here with her husband to live with him. So while he has an alternate address that he could go to, she does not. So I am asking the court to take that into consideration regarding the protection order and who can remain at the house.
All right, thank you. Bond will be set at $1,500 personal recognizance bond with basic supervision. The next court date, ma'am, is July 30th at 8:30 in Division 306. So I've given you a personal recognizance bond, meaning that you don't have to post anything in order to be released today. But if you fail to appear at a subsequent court date, that $1,500 may enter as a judgment against you. Okay, ma'am?
Okay, I understand. Thank you.
All right. All right. Thank you. All right. The court will call 2025 M 1106, Josiah Velasquez Ariano.
I'll waive reading and advisement.
Thank you. Sir, can you hear the court?
Yes, ma'am, I can.
All right. The court found probable cause in this matter for an alleged act of domestic violence. There will be a mandatory protection order that enters in this case. The provision of that protection order requires that you shall not harass, molest, or intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or control a firearm or other weapon. You shall not possess or consume alcohol or drugs. You shall not possess or purchase any ammunition. You shall relinquish for the duration of the order any firearm or ammunition in your immediate possession or control, or subject to your immediate possession or control, and do so within 24 hours. You will also be required to complete an affidavit and file it along with proof of relinquishment with the court within 7 business days. That affidavit that you need to fill out and file with the court was provided to you along with the paperwork pertaining to the protection order. You're also ordered to obey any and all active protection orders and restraining orders issued against you. Also, there is to be no possession or consumption of marijuana, except with a valid medical marijuana card. The mandatory protection order is a condition of bond. The recommendation in this case was for a PR bond with no supervision. Ms. Pearson.
And Your Honor, the PR workup indicates prior arrests or FTAs. I couldn't find anything whenever I searched, so we would not have any objections to the recommendation in this case.
Thank you. If I follow the recommendation, anything further, Ms. Bell?
Judge, I do have an alternate address if the court needs it, though.
Sure.
It's 2421 2nd Avenue. And that would be with his grandparents.
Is that 81001?
3.
A lot of them do, Kelly, don't they? They all put their hair in the same way. No, they're not. Absolutely not required to. I've seen a whole bunch that don't, but yeah, if you just look at the ear back, you can't pick the judge. Even Blanca wears her hair like that more than half the time.
Yes.
3. Thank you.
3.
81003. Okay. With grandparents.
Yes.
How much of Colorado do you think is snowy?
All right. Thank you. Bond will be set in the amount of $1,500
Kelly,
personal
thanks for the
recognizance
bits.
bond
Thank
with
you.
no supervision. Sir, your next court date is July 30th at 8:30 in the morning in Division
Yes, ma'am.
306. So I've given
Okay.
you a PR bond. You don't have
Yes,
to
ma'am.
post any money in order to be released.
Okay, thank you.
However, if you fail to appear at a subsequent court date, that $1,500 could enter as a judgment against you. Do you understand, sir?
Yes, ma'am.
All right. Thank you, sir. Good luck.
Thank you. You have a good day.
All right. And I think that's all of your cases, Ms. Bell.
It is. Thank you. Have a good weekend, everyone.
All right. Thank you.
Give it up to me. Straight up.
The court will call 2025 M 1108 Joseph Bobian.
I like her so far. I mean, it sounds like she could get real stern real quick if
Mr.
you
Bobian,
try
can you
her.
hear the court, sir?
I don't know.
Yes, I can.
All right, thank you. Mr. Bobian, did you see the video played before docket which explains your rights?
Yes, ma'am.
Did you understand the explanation of the rights given in that video?
Yes, ma'am.
Do you understand your rights and do you have any questions about your rights?
No, ma'am.
All right. Do you understand the difference between the types of bonds as explained in the video?
Yes, ma'am.
Okay. So, sir, I'm going to read you your rights. You have the right to enter a plea of not guilty and have the case set for trial. You have the right to be represented by an attorney throughout the trial and at all proceedings leading up to that trial. If you do not have the means to hire an attorney, and if jail is being sought, you can ask the court to appoint one for you at no cost to you. You're presumed innocent of the charges pending against you, and that presumption of innocence remains with you throughout the trial unless the prosecution presents evidence to prove your guilt beyond a reasonable doubt. At trial, you have the right to confront and cross-examine witnesses called to testify against you and to cross-examine those witnesses. You have the right to present evidence in your own defense and to compel the attendance of witnesses by subpoenas. You have the right to remain silent at the trial or to testify in your own defense as you choose. If you choose to remain silent, your silence cannot be used against you. After the trial is over, you have the right to appeal to a higher court to review the trial to determine if it was conducted properly. The arrest charge in this matter is assault in the third degree as a class 1 misdemeanor with a domestic violence basis. So, sir, I'm going to talk to you about the possible penalties. The possible penalties are 0 days in jail up to 364 days in jail with a fine of up to $1,000. The court is now also going to enter a mandatory protection.
Judge Thomas, Taylor Thomas. She's also just not another Judge Fleischer. She didn't get there. But I mean, we'll keep going. We'll see what she's like.
Order in this case. The court found probable cause in this matter for an alleged act of domestic violence. There will be a mandatory protection order that enters in this case. The provisions of the protection order requires that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or control a firearm or other weapon. You shall not possess or consume alcohol or drugs. You shall not possess or purchase any ammunition. You shall relinquish for the duration of the order any firearm or ammunition in your immediate possession or control, subject to your immediate possession or control, and do so within 24 hours. You will also be required to complete an affidavit and file it along with proof of relinquishment with the court within 7 business days. That affidavit that you need to fill out and file with the court was provided to you along with the paperwork pertaining to the protection order. You're also ordered to obey any and all active protection orders and restraining orders issued against you. No possession or consumption of marijuana except with a valid medical marijuana card. The mandatory protection order is a condition of bond. The recommendation in this case is for a personal recognizance bond with no supervision. Ms. Pearson, what's your argument?
Your Honor, based on the underlying allegations and his criminal history, we would agree with the recommendation in this case. I don't see any cases for like almost 40 years, it looks like.
Okay. So, Mr. Bobian, you have the right to make an argument regarding bond. I'll remind you that anything you say can and will be used against you at a subsequent proceeding. The recommendation is for a personal recognizance bond. I'm inclined to follow that. A PR bond is that you don't have to post any money in order to be released. Would you like to make any argument, sir?
I'm fine, thank you, ma'am.
Okay. Sir, do you have an alternate address that you can stay at?
Yes, ma'am.
Can you give that to the court?
3 Stone Acre Court.
3 Stone Baker Court. What's the zip on that?
81005.
81005. All right, sir, I'm going to set bond in the amount of $1,500.
Monica, thank you so much for the bits. Kelly, thank you for the bits. You guys are great. Thank you.
Personal recognizance bond with no supervision. Your next court date is July 30th at 8:30 in the morning in Division 306. Okay?
Okay, thank you.
All right, thank you, sir. The court will call 2025 M525 Keith Davis.
Davis.
We have to be nice to possums because they're very beneficial, even though they're very terrifyingly scary and will kill you. They won't kill you guys.
Mr. Davis, can you hear the court, sir?
Yes.
All right, Mr. Davis, did you see the video that played before the docket which explains your rights?
Yes.
Okay, did you understand the explanation of the rights given in the video?
Yes.
Do you have any questions about your rights?
No.
Do you understand the difference between the different types of bond as explained in the video?
Yes.
Okay, I'm going to read you your rights now, sir. You have the right to enter a plea of not guilty and have a trial in this case, either to a jury. You have the right to be represented by your attorney throughout the trial and all proceedings leading up to the trial. If you do not have the means to hire an attorney, the court will appoint one for you at no cost. You are presumed innocent of the charges pending against you, and that presumption of innocence remains with you throughout the trial unless the prosecution presents evidence to prove you're guilty beyond a reasonable doubt. At trial, you have the right to confront the witnesses and called to testify against you and to cross-examine any witnesses. You have the right to present evidence in your own defense at the trial and to compel the attendance of witnesses by subpoenas issued by the court or your attorney. You have the right to remain silent at the trial or to testify in your own defense as you choose. If you choose to remain silent, your silence cannot be used against you. After the trial is over, you have the right to appeal to a higher court to review the trial to determine if the trial was conducted properly. Do you understand your rights, sir?
Yes.
Okay. All right, a complaint and information was filed in this case on April 9th of 2025, charging you with a single count of assault in the third degree as a class 1 misdemeanor. The possible penalties are 0 days in jail up to 364 days in jail, or a fine of up to $1,000. There will be a mandatory protection order that enters in this case. The provisions of the protection order require that you shall not harass, molest, or intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess or consume alcohol or drugs. There is to be no possession or consumption of marijuana except with a valid medical marijuana card. The mandatory protection order is a condition of bond. Bond has previously been set by the division judge in the amount of $3,500 cash or surety with enhanced supervision. Ms. Pearson.
And Your Honor, we would just be requesting basic supervision in this case based on his history of failing to appear in court.
Do you have an objection? The recommendation was for a personal recognizance bond.
Not to the
What's-
monetary amount, no.
Okay. Okay, sir, you have the right to make any argument regarding bond. I'll remind
Hi,
you
Jude.
again that anything you say can and will be used against you at a subsequent hearing, and you also have the right to remain silent. There's essentially a limited amount of information that I can consider today at a bond hearing. And those are, for example, whether or not you're employed, your residence, how long you've lived in Pueblo, those types of things. Would you like to waive your Fifth Amendment right and make an argument, sir?
No.
Okay. All right, the court's going to make the following findings. The date of offense in this matter was November 25th of 2024. The allegations have alleged to occurred while he was incarcerated, serving a sentence in 2022 CR 1771. However, charges were not filed until April 9th of 2025, and bond was set shortly after that. I'm going to modify bond to a personal recognizance bond, but I am going to order basic supervision. So bond will be set in the amount of $3,500 personal recognizance bond with basic supervision. So, sir, I've given you a personal recognizance bond. Do not fail to appear at a subsequent court date. Okay, Mr. Davis?
Okay,
Your next court date is August 1st at 8:30 in Division 303.
okay,
All right, thank you.
thank you.
All right, the court will call 2025 CR 774 Joaquin Trujillo. Mr. Trujillo, can you hear the court, sir?
Yes,
Did you see the video played before docket which explains your rights?
yes,
Did you understand the explanation of the rights given in the video?
yes.
Do you have any questions about your rights?
No,
Okay. Do you understand the differences between the types of bond as explained in the video?
yeah,
Okay. I'm going to read you your rights, sir. You
okay,
have the right to enter a plea of not guilty and have a trial in this case. You have the right to be represented by your attorney throughout the trial and all proceedings leading up to the trial. If you do not have the means to hire an attorney, the court will appoint one for you at no cost to you. You're presumed innocent of the charges pending against you, and that presumption of innocence will remain with you throughout the trial until and unless the prosecution presents evidence to prove your guilt beyond a reasonable doubt. At trial, you have the right to confront the witnesses called to testify against you and to cross-examine the witnesses. You have the right to present evidence in your own defense at the trial and to compel the attendance of witnesses by a subpoena. You have the right to remain silent at trial or to testify in your own defense as you choose.
Maria, thank you so much for the bits. Thank you so much.
If you choose to remain silent, your silence cannot be used against you. After the trial is over, you have the right to appeal to a higher court to review the trial to determine if it was conducted properly.
Oh
Do you
my
understand your right?
gosh. Maria, you just gifted Kelly a membership on Twitch. Thank you. Thank you. That's awesome.
Sir?
yes,
All right. I'm now going to advise you of the arrest charges in this case. The arrest charges in this case are attempted second-degree murder as a Class 3 felony and a Class 4 felony attempted aggravated robbery. The possible penalties for attempted second-degree murder are 4 to 12 years in the Department of Corrections in the presumptive range, with a minimum fine of $3,000 to $750,000. However, because this is a crime of violence, the possible penalties could be a mandatory prison sentence of 10 to 32 years. The parole period is 3 years for a Class 3 felony. The possible penalties for an F4 attempted aggravated robbery, the presumptive range is 2 to 6 years in the Department of Corrections with a minimum fine of $2,000 up to a maximum of $500,000. However, again, because this may be charged as a crime of violence, the possible penalty could be a mandatory prison sentence of 5 to 16 years in the Department of Corrections. The parole period for a Class 4 felony is 3 years. There will also be a mandatory protection order that enters in this case. The provisions of the protection order require that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts you're charged with committing. You shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location in which the victims may be found. You shall refrain from contacting or directly or indirectly communicating with the victims. You shall not possess or consume alcohol or drugs. There is to be no possession or consumption of marijuana except with a valid medical marijuana license. The mandatory protection order is a condition of bond. The recommendation is for an enhanced cautionary bond. Ms. Pearson?
Your Honor, based on the underlying allegations, we would be agreeing with the recommendation and request a high cash or surety bond with intensive supervision and GPS monitoring. The underlying allegations and the charges are extremely concerning to the people.
Thank you. So, sir, you have the right to make any argument that you want to regarding bond. I'll remind you again that you can say anything that you say will be used against you in a subsequent proceeding, and that you have the right to remain silent. There's essentially a limited amount of information that I can consider today at a bond hearing. And those that information essentially is where you're going to live, your employment, residence, those types of things. So given that information, sir, would you like to waive your Fifth Amendment right and make an argument regarding bond?
If I could.
Go ahead, sir.
Yeah, so with the, like they say, it's allegations or whatever, so I was just trying to get in hold with someone I can talk to. I've been telling them that for a long time. I was trying to talk to the detective to prove my innocence. I'm the only one that
So, sir,
takes
I'm
care of my daughter.
gonna tell you okay, go ahead. You said that you were the
I'm
only one that takes care
innocent.
of your daughter.
Yeah,
Go
I'm
ahead,
the
sir.
only one that takes care of my daughter. I just graduated high school and I have a good paying job. I'm actually supposed to be at work tonight. And I'm out of her mom and everybody, and I'm the only one that takes care of my daughter. My daughter's 23 years old.
Where do you work, sir?
I work at Baymont Inn in Pueblo, Colorado.
How long have you
Hotel.
worked there?
I worked there 7 months now.
All right. Anything else, sir?
No, thank you.
All right, thank you. The court has considered the severity of the pending charges against the defendant in this case. Additionally, there are several co-defendants in this matter. Given the severity of the arrest charges and the facts in the affidavit, the court does have serious community safety risks. So I'm going to set bond similarly to those that have been previously set in the co-defendant's case. Bond is going to be set at $20,000 cash or surety with intensive supervision and
Ouch.
electronic home
Yikes.
monitoring. The court will also find that the defendant may be held up to 24 hours after the defendant is physically present in the jail, and bond has been posted to ensure that the defendant is fitted with any electronic monitoring device. The next court date in this matter is July 31st at 1:15 in Division 504.
Thank you.
All right, I think that's everyone in the jail. Thank you all.
At all?
Thank you, Judge. Have a good day.
Thank you, you too. We'll be off the record.
Do you have any questions about that?
No.
All right. I have to move my stuff. No, that one's fine. Hold on, let me just double check it. No, no one's underneath her. All right. There we go. So this is, it's too tiny, I can't read her name. This is another new judge. I hope they tell us, I can't remember where in Colorado this is. We're about to find out. I'm sure they'll say it. Douglas County is one of the cells, one of the jails, but that doesn't mean this is Douglas County. So we're going to see how she does. Hopefully she does well.
Okay. Let's talk about bond, Ms. Jaramillo.
Judge, just so that the court is aware, the defendant does have a prior sex offense. I know that his pretrial report, they said they were unsure.
Let's fast forward to him. We don't care. We don't want to know. It's too early in the morning to hear him. There we go.
And at 10 o'clock in Lincoln County. Will he need a writ still?
I was not aware of him being held on anything else. I think it
Okay.
was just an arrest on the warrant.
Okay, so Mr. Tyra, do you understand that?
Kind of. I get off
So you-
PR
I'm just
bond and then
giving
go
you-
see Lincoln
Yep,
County.
and then be in
Yes, ma'am.
Lincoln County at August 11th at 10 o'clock for a continued advisement because we can't do the advisement today.
Okay. Yes, ma'am.
Okay,
Thank you, Your Honor.
all right, have a good day.
Thank you, guys. Thank you.
Who is in Douglas County?
Hello, Judge Slade. This is a Spanish interpreter matter, Souza Castro.
Oh, sorry, I didn't realize we had an interpreter. 25M1957, Souza Castro. Oops, you are very digital.
Oh, she sounds good to me. Isn't that
You
Spanish?
sound like a robot. Even though you're speaking Spanish, I still can't.
Let me change this here. Is better?
Yes.
Okay. Sorry about that. Está presentando el caso del señor Sosa Castro 25M1957.
Danielle Jaramillo for the people.
La señorita Jaramillo de la Fiscalía.
Erica Anderson on behalf of Mr. Souza Castro, who appears in custody and would waive any further reading and advisement.
Erika Anderson representando al señor Castro, quien comparece y ya renunció a la lectura completa de el resto del caso.
Thank you. I will appoint the public defender to represent Mr. Souza Castro so long as he remains in custody.
Gracias. Yo voy a asignar al defensor público para que represente al señor Sosa Castro con tal de que él permanezca detenido.
Mr. Souza Castro, are you a member of the United States Armed Services or have you ever been?
Señor Sosa Castro, ¿usted es miembro del militar de los Estados Unidos o alguna vez ha sido?
No.
No.
I am going to enter a protection order which states you shall not harass, molest, intimidate, retaliate against, or tamper with any of the witnesses to or victims of the act you are alleged to have committed.
Yo voy a entrar una orden de protección que dice que usted no puede acusar, molestar, intimidar, desquitarse o manipular nada relacionado con cualquier víctima o testigo del caso que se indica.
Named in the protection order is Jarvin Hernandez.
Y en la orden de protección está nombrado Jarvin Hernández.
Ms. Jaramillo, I have received your proposed protection order. Are there any other conditions you're requesting?
Señorita Jaramillo, he recibido la propuesta de la orden de protección. ¿Usted está requiriendo alguna otra cosa?
No, thank you.
No, gracias.
Ms. Anderson, are you asking to be heard on the protection order?
No, Your Honor, thank you.
¿Quiere la señorita Anderson hablar de la orden de protección? No, su señoría.
So, Mr. Souza Castro, I am entering this protection order as proposed. Violating this protection order could result in additional criminal offenses and could be a violation of your bond.
Entonces, señor Sosa Castro, estoy entrando esta orden de protección como condición de su fianza. Si usted la quebranta, puede haber cargos contra usted.
Do you have any questions about that?
¿Tiene alguna
No
pregunta
one.
acerca de eso?
No one is talking with me. Not one person.
No.
Let's talk about bond, Ms. Jaramillo.
La señorita Jaramillo, hablemos de fianza.
Judge, we are asking for a cash surety bond, but are okay with $1,000 or $500 cash surety. We're asking for a cash surety due to the fact that the defendant has an FTA warrant from a case recently that it was openly active, as well as the fact that he has been arrested for the alien admissibility, and that people do have concerns for deportation, which would create an issue with the defendant being able to appear in the future.
Su señoría, nosotros estamos pidiendo una fianza con seguridad de $1,000 o $500 y una de las razones es porque hay una orden de arresto debido a un FTA y las condiciones mencionadas.
We would also request pretrial services.
I'm sorry, interpreter didn't get that.
We would also request pretrial services.
Thank you. Y también estamos solicitando servicios de prejuicio.
Ms. Anderson?
Your Honor, we are joining in with the recommendation of pretrial for a $1,000 PR bond.
Su señoría, nosotros estamos de acuerdo con prejuicio, con la fianza de $1,000 bajo palabra.
Mr. Sosa Castro's failure to appear in the Moffat County case is from 2022.
La comparecencia del del señor Sosa Castro en el caso de Mofa es del 2022.
Since then, he's had no contact with law enforcement.
De esa fecha no ha tenido ningún contacto con la ley.
He does have a stable residence in Denver.
Él tiene residencia estable en Denver.
He has reliable transportation to get to and from court.
Kelly, thanks for the bits. Thank you so
Transporte,
much.
que puede usar para ir y venir del tribunal.
He's been employed as a painter for the last year and is scheduled to work this week and may lose that job if he were to stay in custody.
Y él está empleado como pintor el último año y tiene un trabajo esta semana que podría perder si permanece en custodia.
He does have family in Colorado, a sister and brother, and he is financially responsible for his 2 kids.
Él sí tiene familia, una hermana y un hermano, y es responsable financieramente por sus 2 hijos.
And I would also be objecting to pretrial supervision in this case based on the level of charge, and also it's not recommended by pretrial themselves.
Y yo también me opondría a supervisión de prejuicio debido al nivel de la queja y que no es apropiado.
Okay, thank you. I'm going to set bond at $1,000, personal recognizance bond.
Bueno, voy a poner fianza de $1,000 bajo palabra.
Conditions of that bond is appear for all your court dates and no new criminal offenses.
Condiciones de esa fianza son que comparezca a todas las cortes y no cometa nuevos delitos.
Any questions about your bond, Mr. Sosa Castro?
¿Alguna pregunta de su fianza?
¿Lo puedo pagar hoy? Los 1,000.
Can I pay it today?
It's just your signature. It's your promise to appear.
Es solamente su firma lo que tiene que hacer para salir. Que prometa que vuelve.
Okay, any other questions?
¿Alguna otra pregunta?
Es todo, gracias.
No, that's all. Thank you.
We set this for a pretrial conference August 6th at 8:30 in FAC.
Vamos a sentar esto para agosto 6 para una conferencia de prejuicio a las 8:30 en FAC.
That work for the people?
¿Se queda
Yes,
bien a la
Judge, thank you.
oficina? Sí, su señoría, gracias.
Ms. Anderson?
Yes, Your Honor, thank you.
Okay,
Sí, su señoría, gracias.
thank you.
Gracias.
Judge, this is also a Spanish interpreter case. Pablo Vilches.
Thank you. 25 CR 763. Vilches?
25 CR 763. Sorry, Your Honor.
Sorry,
Vilches,
Danielle
Vilches.
Jaramillo for the people.
Daniel Jaramillo de la Fiscalía.
Erica Anderson on behalf of Mr. Vilches, who appears virtually in custody and would waive any further reading and advisement.
Erika Vilches representando al señor. I'm sorry, Erika Anderson, intérpretes correctos.
2022 CR 1771. However, charges were not filed
All
until
right,
April
I
9th
think-
of 2025.
I think we're
and
streaming
bond
again.
was set shortly after that.
I hope you can hear
I'm
me.
going to modify bond to a personal recognizance
cat
bond, but I
shut my
am going to
computer
order
off.
basic supervision.
If you noticed,
So
right
bond will
before
be
I
set in
died,
the
I
amount
was
of
reaching over,
$3,500
trying to
personal
stop it.
recognizance bond with basic
But, oh,
supervision.
Jesus, no.
So, sir, I've given you a personal recognizance bond. Do not
I'm
fail
not
to
muted.
appear
I
at a
just
subsequent
really am
court
not
date.
muted.
Okay, Mr.
Oh.
Davis?
Okay.
Your next court date is August 1st at
Yeah.
8:30.
My
in
cat shut my
Division
computer off.
303.
Okay.
So now I'm going
All
to
right,
get rid of
thank
that
you.
cat.
Thank you.
No, I'm not. No, I'm not. I'm gonna.
All right,
I'm
the
gonna
court
probably
will
get
call
that cat some treats
2025
today, but
CR
I'm still very
774
mad
Joaquin Trujillo.
at that cat. Very, very mad. Because now I have to find out where we were.
Mr.
I
Trujillo,
know we're
can
not
you
at
hear
this
the
judge
court, sir?
anymore, so I will.
Yes.
I will.
Did you see
Oh,
the
no.
video played before?
Wait a second. That was playing, and I didn't hear it playing at all. That's not good.
Okay, so
For
Mr. Batts, we'll
docket,
see you
which
back in a
explains
couple
your
weeks, and we'll go
That's
from there.
just. Did you guys hear the video playing right now? I mean, it was playing while I was talking. I don't know if you guys heard it or not. I'm gonna just go to, yeah, we didn't want that guy. I'm just gonna go here. I'm gonna start it right here. Listen, Nan, we are slowly getting rid of them, but not fast enough, and it's still a ton of cats. Ton of cats. I can't hear the video, which means once I press play, I won't know what's going on. I won't know if it's bad. I won't know if I need to fast forward it. I won't know anything. So maybe I can fix that on the fly. Okay, CJ, I can flash messages. I mean, I can't flash messages because of Twitch, but now the cat's mad because I yelled at it. But I can try to fix it so it's set up for YouTube only. I just won't be able to flash Twitch messages, and there's nothing I can do about it. It's a known bug with Twitch. So there, now we can see everybody. The interpreter's still there. Yeah, it's new software. I got new software like, I don't know, 2 weeks ago. It's been causing all kinds of problems with me. So I just finally got Twitch up so we can see it. No, it wasn't the orange one. It was the one that was declawed. So Pity can actually do whatever he wants. Anything he wants. For the rest of his life, he can do anything he wants because some asshole declawed him. And now he don't have no claws. So he, struggles. He struggles. So I give him anything he wants. You don't have to. You really don't. Everybody, same people watch. They've got the links. You guys know the links. How about this, CJ? If you want links to my Discord, which is fun, to my, what do I call them? PayPal, Cash App, Venmo, whatever. My Patreon has other stuff. Just go to my channel. Go to my channel and there. You can get the links. I'll say that every stream. Now you don't have to worry about it. If you need the link to Discord, just shout and we will throw it in there. But it's on my channel. Let's get back to here. Something doesn't look right. There we go. That's better.
It states armed services, or have you ever been?
I can't hear anything.
Señor Sosa Castro, ¿usted es miembro del militar de los Estados Unidos o alguna vez ha sido?
No.
No.
I am going to enter a protection order which states you shall not harass, molest, intimidate, retaliate against, or tamper with any of the witnesses to or victims of the act you are alleged to have committed.
Yo voy a entrar a una orden de protección que dice que usted no puede acusar, molestar, intimidar, desquitarse o manipular nada relacionado con cualquier víctima o testigo del caso que se indica.
Named in the protection order is Jarvin Hernandez.
Y en la orden de protección está nombrado Jarvin Hernández.
Ms. Jaramillo, I have received your proposed protection order. Are there any other conditions you're requesting?
Señorita Jaramillo, he recibido la propuesta del orden de protección. ¿Usted está requiriendo alguna otra cosa?
No, thank you.
No, gracias.
Ms. Anderson, are you asking to be heard on the protection order?
No, Your Honor, thank you.
¿Quiere la señorita Anderson hablar de la orden de protección? No, su señoría.
So, Mr. Souza Castro, I am entering this protection order as proposed. Violating this protection order could result in additional criminal offenses and could be a violation of your bond.
Entonces, señor Sosa Castro, estoy entrando esta orden de protección como condición de su fianza. Si usted la quebranta, puede haber cargos contra usted.
Do you have any questions about that?
¿Tiene alguna pregunta acerca de eso?
No.
No.
Let's talk about bond, Ms. Jaramillo.
Señorita Jaramillo, hablemos de fianza.
Judge, we are asking for a cash surety bond, but are okay with $1,000 or $500 cash surety. We're asking for a cash surety due to the fact that the defendant has an FTA warrant from a case recently that it was openly active, as well as the fact that he has been arrested for the alien admissibility, and that people do have concerns for deportation, which would create an issue with the defendant being able to appear in the future.
Su señoría, nosotros estamos pidiendo una fianza con seguridad de $1,000 o $500 y una de las razones es porque hay una orden de arresto debido a un FTA y las condiciones mencionadas.
We would also request pretrial services.
I'm sorry, interpreter didn't get that.
We would also request pretrial services.
Thank you. Y también estamos solicitando servicios de prejuicio.
Ms. Anderson?
Your Honor, we are joining in with the recommendation of pretrial for a $1,000 PR bond.
Su señoría, nosotros estamos de acuerdo con prejuicio, con la fianza de $1,000 bajo palabra.
Mr. Sosa Castro's failure to appear in the Moffat County case is from 2022.
La comparecencia del señor Sosa Castro en el caso de Moffat es del 2022.
Since then, he's had no contact with law enforcement.
De esa fecha no ha tenido ningún contacto con la ley.
He does have a stable residence in Denver.
Él tiene residencia estable en Denver.
He has reliable transportation to get to and from court.
El transporte que puede usar para ir y venir del tribunal.
He's been employed as a painter for the last year and is scheduled to work this week and may lose that job if he were to stay in custody.
Y él está empleado como pintor el último año y tiene un trabajo esta semana que podría perder si permanece en custodia.
He does have family in Colorado, a sister and brother, and he is financially responsible for his 2 kids.
Él sí tiene familia, una hermana y un hermano, y es responsable financieramente por sus 2 hijos.
And I would also be objecting to pretrial supervision in this case based on the level of charge, and also it's not recommended by pretrial themselves.
Y yo también me opondría a supervisión de prejuicio debido al nivel de la queja y que no es apropiado.
Okay, thank you. I'm going to set bond at $1,000, personal recognizance bond.
Bueno, voy a poner fianza de $1,000 bajo palabra.
Conditions of that bond is appear for all your court dates and no new criminal offenses.
Condiciones de esa fianza son que comparezca a todas las cortes y no cometa nuevos delitos.
Any questions about your bond, Mr. Souza Castro?
¿Alguna pregunta de su fianza?
¿Lo puedes pagar hoy? Los 1,000.
Can I pay it today?
It's just your signature. It's your promise to appear.
Es solamente su firma lo que tiene que hacer para salir. Que prometa que vuelve.
Okay, any other questions?
¿Alguna otra pregunta?
Es todo, gracias.
No, that's all. Thank you.
We set this for pretrial conference August 6th at 8:30 in FAC.
Vamos a sentar esto para agosto 6 para una conferencia de prejuicio a las 8:30 en FAC.
That work for the people?
¿Se queda
Yes,
bien a la
Judge, thank you.
fiscalía? Sí, su señoría, gracias.
Ms. Anderson?
Yes, Your Honor, thank you.
Okay,
Sí, su señoría, gracias.
thank you.
Gracias.
Judge, this is
Yes.
also a Spanish interpreter case. Pablo Vilches.
Thank you. 25 CR 763. Vilches?
25 CR 763. Sorry, Your Honor.
Sorry,
Vilches,
Danielle
Vilches.
Jaramillo for the people.
Daniel Jaramillo de la Fiscalía.
Erica Anderson on behalf of Mr. Vilches, who appears virtually in custody and would waive any further reading and advisement.
Erika Vilches representando al señor. I'm sorry, Erika Anderson, intérpretes corrección. Erika Anderson representando al señor Vilches, quien está presente y ha renunciado a todas las advertencias.
All right, I will appoint the public defender to represent Mr. Vilches so long as he remains in custody. Sir, are you a member of the United States Armed Services or have you ever been?
Le vamos a asignar el defensor público con tal de que usted permanezca detenido. Señor, ¿usted es o ha sido miembro de las fuerzas militares de aquí?
Perdón.
What was that?
Are you a member of the United States Armed Services or have you ever been?
¿Usted es miembro de las fuerzas militares de los Estados Unidos o lo ha sido alguna vez?
No.
No.
I am going to enter a protection order which states you shall not harass, molest, intimidate, retaliate against, or tamper with any witnesses to or victims of the act you are alleged to have committed.
Entonces yo le voy a dar una orden de protección que le dice que usted no puede ni acosar, ni molestar, ni intimidar, ni desquitarse, o manipular o influenciar ningún testigo ni ninguna víctima de los actos que se le acusan.
Additionally, the
Está bien.
people are asking that you shall vacate the home of the victims, stay away from any location where they are likely to be found, go ahead, I'll wait for the interpreter.
Y también se le dice que usted tiene que dejar la casa de la víctima si es que usted vive ahí y también de la víctima.
Named in the protection order are Giovanni Clito, Fernando Clito, and Gabriela Martinez.
También en la orden de protección está Giovanni Clido, Fernando Clido y Gabriela Hernández.
People are also asking that you shall refrain from contacting or directly or indirectly communicating with them.
El tribunal, la fiscalía está pidiendo que usted se abstenga de comunicarse con ellos de cualquier modo.
That you not possess, purchase, or control a firearm or other weapon.
Que usted no compre ni tenga una arma de fuego ni ninguna otra arma.
Ms. Jaramillo, are you asking for any additional conditions or to be heard on the protection order?
La señorita Jaramillo está pidiendo cualquier otra condición o algo de la orden de protección.
No, Judge.
No, juez.
Ms. Anderson, are you asking to be heard on the protection order?
No, Your Honor, thank you.
Señorita Anderson quiere que hablen de la orden de protección, no su señoría.
All right, Mr. Vilches, violating this protection order could result in additional criminal offenses and could be a violation of your bond. Do you have any questions about the protection order? I am entering it as proposed.
Señor Vilches, si usted quebranta esta orden de protección, van a haber cargos contra usted y podría ser quebrantar la fianza. ¿Usted tiene alguna pregunta acerca de esta orden de protección?
De eso de armas, yo nunca he manejado armas, o sea, no sé por qué se me acusa eso de armas.
I've never had firearms.
So it should be easy to
Ok.
follow, yeah?
Entonces le va a quedar fácil seguir todo, ¿cierto?
Any other questions?
¿Tiene alguna otra pregunta?
No.
Right.
No.
Violating this protection order could result in additional criminal offenses and could be a violation of your bond. Ms. Harmio, let's talk about bond.
Quebrantar esa orden de protección podría resultar en cargos y de quebrantar la fianza.
Judge, the people would ask that bond be set at the $7,500 cash or surety, which is the guideline amount.
¿Qué dice la fiscalía? La fiscalía dice que la multa o la fianza debe ser citada a $7,500 en efectivo.
Defendant does come back as medium risk, both in criminal activity score as well as the failure to appear score.
El acusado tiene un riesgo mediano, tanto penal como el hecho de no comparecer en las cortes.
The people's biggest concern is the defendant not returning to court, given that he's currently on FTA status. It appears in 2 cases. And in the 2 cases he's had in Douglas County, he FTA'd in both of those as well.
El que le preocupa a la fiscalía es que él tiene 2 casos FTA. Esos son 2 casos, incluyendo el de Douglas también.
Because of that, the people are also requesting pretrial services so that they can make sure he is getting to court.
También por eso es que la fiscalía está pidiendo servicios de prejuicio para que se aseguren que él sí va a las cortes.
Okay, Ms. Anderson.
Señorita Anderson.
We're asking the court to consider a reduction to $1,000 cash or surety.
Su señoría, nosotros le estamos pidiendo al tribunal que considere la reducción a $1,000 en efectivo.
Mr. Vilches lives in Castle Rock and is responsible for paying the rent.
El señor Welches vive en Castle Rock y es el responsable de pagar el arriendo.
He has 3 roommates who depend on him to pay the rent.
Es el que se queda para pagar la renta de todos.
He also does have family in Colorado, including 1 child that he's responsible for financially providing for.
También él tiene un menor en Colorado, del cual él es responsable de mantenerlo.
He currently works in landscaping and is scheduled to work this week and could potentially lose that job if he were to remain in custody.
Él trabaja en el zacate y podría perder su trabajo si permanece en custodia.
He represents that he now has reliable transportation to get to and from court.
Y él está representando que él sí tiene transporte para ir y venir del tribunal.
For Mr. Vilches, anything above $1,000 cash or surety would essentially be a no bond hold.
Para el señor Wilches, cualquier fianza que sea mayor a $1,000 sería como no darle fianza.
And I believe with the protection order and the addition of pretrial supervision as requested by the people, Mr. Vilches can have conditions of bond that assist him with meeting his court dates outside of a monetary condition.
Y ya como la fiscalía ha pedido servicios de prejuicios, el señor Welches podría tener esos servicios que le ayuden a cumplir con las condiciones.
I'm going to set bond at $7,500 cash or surety.
Vamos a poner la fianza a $7,500 en efectivo.
Conditions of that bond, Mr. Vilches, you shall not leave the state of Colorado without permission of the court.
Las condiciones de esta fianza son que el señor Welches no puede irse del estado sin permiso del tribunal.
Appear for all your court dates.
Comparecer a todas las fechas de corte.
And commit no new criminal offenses.
Y no cometer ningún delitos nuevos.
Comply with the terms and conditions of the protection order.
Cumplir con los términos y condiciones de la orden de protección.
And I am going to place you on pretrial supervision based upon your failure to appear history.
Y debido a que usted tiene un historial de no comparecer a la corte, lo voy a poner en supervisión de precaución.
Mr. Vilches, do you have any questions about your bond?
Señor Vilches, ¿tiene preguntas acerca de su fianza?
Pues la verdad ahorita pues no tengo dinero, o sea, pues no he trabajado mucho, o sea, pues nada más pues sale para ir pues manteniéndose uno y para las rentas.
Thanks for the bit
pero
small. Thank you.
de hecho, como habíamos hablado en la otra corte, o sea, la iba a pagar en en pagos, o sea, me dieron tiempo, o sea, y pues sí lo iba a hacer. O sea, de eso iba a venir
Un
hoy.
segundo, señor, que tengo que interpretar. Deme un segundo. In reality, I work and I don't have extra money. It's only to support myself and to pay the rent. And with the other court, they had given me time to make payments, and I was gonna make payments, but
Okay, so I've set the bond amount. Your attorney let me know all of those things. Do you have any questions about the condition of your bond?
su abogada ya me comentó de esas situaciones. ¿Usted tiene alguna pregunta acerca de las condiciones que le di para cumplir la fianza?
Pues sí, si me dan tiempo, o sea, pues me hago responsable en pagar mi FIFA de cuenta, pues lo que debo, o sea, pues.
¿Ok? Señor, ¿puede repetir? Interpreter only that I will be responsible to pay.
Pues como decía, o sea, pues trabajando bien necesitaría tiempo porque pues nada más alcanza como para comer, para ir saliendo, o sea, con tiempo sí, o sea, sí puedo pagar lo que se me da.
What I was saying is I do need time because with time I could pay because when I work, I basically just work and get enough money for food. So I would need time to pay that.
Well, that's your bond amount. All right, do you have any questions about the conditions or the things that I said about bond?
Esa es la cantidad de fianza que tiene que pagar. Aparte de eso, ¿usted tiene alguna pregunta acerca de las condiciones o de lo que tiene que hacer?
No.
No.
All right, so let's set this for filing of charges July 31st at 11 in FAC.
Vamos a presentar esto para presentación de cargos en julio.
Okay, well, you got the bond, $7,500. So there's only a couple minutes left in there anyway. I'm going to switch it to a different judge. Oh no! Wait. Okay. And I'm sorry, my son is swearing. My son is terrible. Wait. I didn't give you permission to start yet, sir. You shut up. I can't hear anything. I just switched it to this guy, and I can't hear anything because my cat shut my computer off in the middle of a stream. So, I have no idea what's going on. But I'm just going to press play and we'll just get through this. We'll just get through this stream. Let's just get through this. I wonder. Hold on. I'm just going to try and add it again and hopefully, maybe, I can hear it. It should just take 2 seconds. I'm almost there.
Ms. Jones.
Yeah, so Mr. Batts
I
had
can't
advised
hear
me this
anything.
morning that he does want to set for trial. However, at this
So I
point,
don't know if
think
it's
that's a good
bad
idea. I do intend to file competency
or
motions
not.
tomorrow.
You guys have to tell me.
To put a hold on this case as of
Oh,
right
you
now,
can't
just
hear
based
that?
on my interactions that I had with him this morning.
You can hear that now, though, right?
Well, I mean, I understand that. I guess I'm a little confused as to why we didn't address the competency issue earlier, Ms. Jones, since the district court attorney had already filed it a couple weeks ago.
Yeah,
Kelly,
and
you can't hear
The
that?
reason that I didn't do that, and I don't want to go too far into my
Sure.
interactions with him, but I have had no interactions that even gave me any indication that there could be a competency issue. I think that it's possible that Ms. Atkinson maybe spoke to him during different times in the day, and that led to her conclusions, but the first time that gave me concern was this morning when I interacted with him, so I do intend to file a competency motion based on that.
It was very convenient after I filed a complaint against your ability as an attorney for you to make that lodge.
Yeah, I mean,
Point that out.
yeah, here's where things stand, Mr. Batts, sorry. When the issue of competency is raised, what happens is there's a stay in the proceedings. And so any sort of deadlines that exist in the case are, they don't run during the time period while the court addresses the competency issue. And so while I anticipated we were likely going to be setting for trial today, it doesn't really make sense to set it today because the competency motion is going to be filed and the proceedings are going to be stayed while we address that competency issue. And so what the court is going to do is set this for status in the near future so that we can address the competency issue. How long do you think you'd take to file the competency motion, Ms. Jones?
I anticipate that I can file it this afternoon.
Okay. You can also file the motion as one to receive the competency evaluation in the felony cases if you'd like. That way we don't have to do duplicative interviews and things like that. What I'll do is I'll bring this back then for status in 3 weeks. My hope is that maybe the competency issue's been resolved because it was raised earlier in July on the felony cases. And then that way, when you come back in September, Mr. Batts, we can make some progress and figure out what we need to do on the case. And so what I'd like to do is bring you back to court on September the 3rd at 1:00 p.m. That way we can, if we're going to enter a not guilty plea, we can do it that date. And we can hopefully figure out what direction things are going. And so is that available for the prosecution?
Yes, Your Honor.
Okay. So Mr. Batts, we'll see you back in a couple weeks and we'll go from there. All right. Thank you.
I'm ready on Mr. Daniels.
All right. Let's call Mr. Daniels. This is 24T820, 24CR923, and 25T1579. We've got Mr. Daniels present with Ms. Jones. We've got Mr. Collinsworth with the prosecution. We're scheduled here today for status. Ms. Jones?
Mr. Daniels would like to address bond today. I was able to put the DA on notice this morning, so if he's prepared to address it, we would like to move forward today.
All right, Mr. Collinsworth?
That's fine, Judge.
Okay, let's address the issue of bond.
Okay, so we're addressing the bond in 24 CR 923. There's a cash only bond. We're asking the court to modify it to a PR bond or in the alternative, a cash or surety bond that Mr. Daniels could post. I know that the court is likely concerned about Mr. Daniels' FTA history and the fact that he was kind of MIA for quite some time. I do think that based on my conversations with him, his circumstances have changed a little bit that have caused him to reprioritize resolving his cases. He recently started a job doing commercial and residential painting. That's the first job that he's held consistently over the past several years, and he is very proud of that job and does want to continue doing that whenever he is out of custody. He's also recently got a phone. He hasn't had a phone or a way that I can contact him for a year. He's been able to get that after he started this job. He's also advised that his mother is on oxygen. She does have difficulty moving around the house. At this point in time, she doesn't have anyone that's able to help her run errands or do anything like that. He is the only person that she can rely on at this point, and he wants to be home to be able to help her with that. He's also living with her, so he does have a place to stay. He does have a way to court. He's advised that his uncle can take him to court or he can take the bus. It does look like after he was released, he did miss that court date on August 4th. We had a conversation about that. He said that his ride didn't show up, and at that point, he didn't see that there was a point in trying to come to court or report to probation. I told him that that wasn't a good idea. We had a conversation on how to move forward if something like that happens again, but he does understand the importance of communicating with me and staying in touch and showing up to court. So we're hoping that, given his circumstances right now, he's going to prioritize these cases moving forward and continue to show up. So we're asking for a PR bond.
All right, let me go over to the prosecution. Mr. Collinsworth?
Thank you, Your Honor. So clearly people are concerned about his ability to appear for court with his failure to appear history, in addition to his compliance with probation. So it's not only his FTA history necessarily from court, it's also he's not been complying with probation either. Because of this history, I'm going to oppose modifying bond in this case. I'll defer to the court, but I just don't think that we have had any showing that he is able to or willing to comply with either probation or showing up for court based on this history. So I'd ask the court to keep bond as said.
All right, thank you, Mr. Collinsworth. Well, this probably isn't a surprise to Mr. Daniels, but I'm not willing to modify the bond. You know, the way that things have been going in this case is that Mr. Daniels hasn't been reporting or checking in with probation or doing what he's supposed to do regarding probation. His probation officer was present back when we talked about this issue in February of 2025. Shortly thereafter, Mr. Daniels absconded again, and he went off the radar. He stopped showing up on these cases. He certainly hasn't been checking in with probation, or he would have been remanded and taken into custody earlier. And so that's not happening. In his cases, he's missed court a substantial number of times. When I looked earlier in 24 CR 923, I think he's missed court 6 times on that case. Or maybe that was in the other one. Maybe that was in 24 T820. Yeah, it was in that case that he's missed court 6 different times. And so there's no confidence that the court has that Mr. Daniels will show up. Quite frankly, these cases have been pending for a year. There's no reason why they should be pending this long other than the fact that Mr. Daniels has not been showing up to court. In fact, when we were back in court in March of 2025, there's information that there was a disposition that the parties had reached, but we still don't evidently have one here today. And so the court declines to modify the bonds in these cases. And so, Ms. Jones, how would you like to proceed?
I would just ask for 3 weeks set over. Mr. Collinsworth has advised that he should have an offer out soon.
Well, there was an offer out beforehand.
There was
that
a
Mr.
disposition, but he's since picked up new cases, and those aren't included in that disposition.
Okay. Well, I mean, I can set it over 3 weeks. I'm hoping to have resolution on that date, though, then. Why don't we try to come back on Wednesday, September the 3rd at 1? Would that work for you, Ms. Jones?
That works for me.
And then would that work for you, Mr. Collinsworth?
It would, Judge. And with the trials being vacated tomorrow, I intend on having an offer sent out tomorrow on these cases. So we should have movement pretty soon.
Perfect. I mean, I think the new case is not particularly complicated from what I could see. It's just a no proof of insurance. And so that was why I'd been hoping maybe there would be a resolution today.
There's also a possession case. I think he was also charged with a DM1 too. I don't think the traffic case is the only one. But I agree. I do think that it's possible to have a resolution in 3 weeks.
Wait, is there a DM1 case that I don't have on my docket? Is there maybe another new case I didn't call?
Maybe. 1 second.
Because I didn't see that when I was looking earlier. Let me just pull that up.
I think it's 25M 2145.
Oh, okay. I didn't see that. Let's go ahead and call that case. So the court's going to go ahead and call 25M 2145. That case, if it's not already assigned to Division 1, is hereby assigned to Division 1. That court date in October is vacated, and it'll return with the other cases on September 3rd at 1:00 p.m. That makes sense. I didn't see that there was that case as well, and so I completely understand now how it complicates things for purposes of a disposition. So, Mr. Daniels, we'll see you back in 3 weeks, and we'll go from there. Okay?
Can we call John Smith?
Yeah, let's go ahead and call Mr. Smith. And so, go ahead, Mr. Smith, come on over. This is 23M 1405, 24M 2212, 24M 5182, and 25M 430. We've got Mr. Smith present with counsel Ms. Jones. We've got Mr. Williams with the prosecution. We're scheduled here today for status. Ms. Jones?
Judge, we're asking
John Smith,
for
come on.
a set over in this case. We're still waiting on an offer for a resolution. We don't have a global offer, but it's been my understanding that that's how these things are going to resolve. He does have some ongoing medical issues that he's been dealing with upstairs. He's been able to get a furlough for some of those issues, but it's kind of put his felony cases upstairs on hold, which is why these cases are moving along fairly slowly.
All right, well, the court will point out, for example, 24M2212 has been pending since July of 2024. And so we're now past a year into the case. Is there a global offer that's been extended that involves these cases?
Your most recent one, though?
Okay.
There
Well,
has been no misdemeanor offer extended to me. If there was a global offer, I was not included in an email chain, but Mr. Smith is indicating that there was a global offer.
okay. Well, so I think we probably all need to follow up on this issue because next court date, what I am going to do is I'm going to set Mr. Smith's cases for trial in light of how long the cases have been pending. And so, if they need to be separated from a felony for purposes of negotiations, I don't have any objection to that. I don't have an objection setting them for trial. But the reason that I brought Mr. Smith here today is I can't just have these cases penned indefinitely for more than a year. And so why don't we try to come back in 3 weeks for entry of plea one way or the other on September 3rd at 1:00 p.m. Does that work for you, Ms. Jones?
Yes, Judge.
And then does that work for you as well, Mr. Williams? Okay, so we'll come back then. And Mr. Smith, I hope that everything's okay with your health right now, and I wish you the best of luck trying to address that. And so,
I'm also ready on Mr. Kraus.
all right, let's call Mr. Kraus. This is 25M2135. Go ahead and take a seat there, Mr. Kraus. And we've got Mr. Kraus here with counsel Ms. Jones. We've got Mr. Rocky with the prosecution. We're scheduled here today for status. Ms. Jones.
Mr. Kraus is hoping to address bond in the 25M2135 case. I did send notice this morning. It is a VRA case. So I would defer to Mr. Rocky as to whether he's ready.
I don't think it is VRA because it's just a violation of protection order, but it's one where I'd want notice to be given. But
Yeah, I wasn't able to speak with the victim. It is not a VRA case, as he said. The victim did give us some input just 3 days or 2 days ago when this bond was set. But it's possible, that position has changed. I wasn't able to get a position though. So I would like some more time to get a victim position.
all right, why don't we set this over? My information is I potentially have tomorrow open, so we can address the issue of bond tomorrow. Would that work for you, Ms. Jones? I could do Friday as well.
Tomorrow's okay.
Well, yeah, the sooner the better with these health issues.
I mean, obviously I would prefer to do it today if it's not a VRA case, but if the court is inclined to set it over, we would like to set it over to tomorrow.
Yeah, I mean, in light of the nature of the charges here and the other pending charges that Mr. Kraus is facing, I would like to have the opportunity for the victim to potentially provide input to the prosecution. And so I am going to set it over to tomorrow, which would be the 14th at 1:00 p.m. And we can address bond. I am going to call Mr. Kraus's other cases. That's 21M2685, 25M1605, and 25M1945. Those cases will also come back with Mr. Kraus tomorrow at 1:00 p.m. Yep, I'm going to get you the same court date on all of them, which is going to be tomorrow. And then we'll get a new court date from there, Mr. Kraus. That way we're going to keep all 4 of your cases together moving forward.
Oh, okay.
Yep. So I'm going to vacate the 25th date. You're going to come back on those tomorrow, the 14th. Okay?
Okay.
All right, we'll see you then.
Thank you, Judge.
I see that Ms. Swallow is with us on WebEx. Ms. Swallow, just so you know, I think that your client is potentially in treatment, and I don't see that he's present, so that's why I have not called him yet. And so I'm not sure if you can hang out a little bit longer, but that's why I have not called your case yet.
Thank you, Judge. I've also got Mr. Russo, who's in custody.
Oh, you
And
do?
then-
Oh, yeah, okay.
With respect to
call
Mr.
that.
Thank you, Judge. With respect to Mr. Shelton, I'm not sure if there's a way for the court to check and see if he's in the WebEx waiting room. He's indicated to me that that is where he is.
I don't see that he's in. I don't have anybody waiting in the waiting room, so he might be in the wrong room.
Okay. Okay, thank you, Judge. Yeah, we could call Mr. Russo and then pass Mr. Shelton.
All right, let's go ahead and call Mr. Russo. This is 25M1612. We've got Mr. Russo present with counsel Ms. Swallow. We've got Mr. Williams.
Bev, hello. Josh, I would not want to get arranged with anybody but you guys.
Mr. Shelton.
With the prosecution. Ms. Swallow?
Judge, we were hopeful to have a resolution today. However, Mr. Russo has new case 25 CR 697. And so I've reached out to the prosecution to see if there's some sort of global that might resolve both. For that reason, we're asking to continue, ideally sometime past September 4th, which is when he's next set on that other matter.
Yeah, I could bring this back on Wednesday, September the 24th at 1:00 p.m. Would that work for you?
Just one moment here. Yep, that works for us.
Does that work for the prosecution?
It does, Your Honor.
Okay. Then, Mr. Russo, we'll see you back in 6 weeks from now on this case. Yep. All right, thank you. And then I'll keep a lookout for Mr. Shelton. I don't see him yet, but I'll recall that as soon as I can.
Appreciate it.
All right, I see that we've got, that is Mr. Davis, right? Okay, are we ready on Mr. Davis? I don't see that Ms. Spradlin is here yet. Do you know, is she gonna be present, Ms. Jones?
I will send her a message. I'm not sure that she's with us.
Okay. All right, I think we can call Mr. Meyer since he refused, right? All right, so let's go ahead and call Mr. Meyer. This is 25M 1971, 24M 5005, People's City of Colorado versus Alfred Meyer. Mr. Meyer refused transport here today. His attorney had previously requested to bring him back on, what was the date that she'd requested? Ms. Jones, this is your case. I didn't want to interrupt you while you were talking about, then Mr. Meyer,
Mr. Meyer.
he
yes.
refused transport today. If you can come on up, we're just going to get a new court date. What was, are you requesting September 3rd at 1?
That's correct. Yeah, I did send an email. I think it was like 10 minutes before noon. So.
Yeah, so why don't we go ahead and if it works for the prosecution, bring him back, it'd be Mr. Rocky on September 3rd at 1:00 p.m.?
That's fine.
Okay, so Mr. Meyer will return then.
Thank you, Judge.
And so I think we're just waiting for Mr. Shelton and Ms. Spradlin. Ms. Jones, Ms. Spradlin just entered, and so her entry of appearance is pending in the court's file.
Okay, that probably makes sense. She's typing right now, so I'll have no.
Okay. Oh, I see that Mr. Shelton is with us. Mr. Shelton, can you hear us okay?
Sure, I can.
Okay, we can hear you. It's very faint, but we can hear you. This is, let me just pull up the case numbers, 25M5074, 24M1544, People's City of Colorado versus Christopher Shelton. We've got Mr. Shelton present from treatment, Ms. Swallow and Ms. Mueller here on behalf of Mr. Shelton, Mr. Williams with the prosecution. We're scheduled here for status. House.
Please, please, for the love of God, nobody ever bail me out. Please, don't bail me. Listen, there's no cats in there. There are no cats in prison. So let's just stay there for a little bit. Let's be quality control people and see if it really is as bad as people say it is. Just leave me in there. I'm writing a book. I'm research on a book about prison. So whatever you do, do not bail me out. Please.
Treatment going so far, Mr. Shelton?
Sir, I'm not in treatment yet. Okay,
Oh,
so
you're not, okay.
no, sir. Some stipulations came up, and but I should be within 24 hours. Is the issue?
Oh, within 24 hours. Okay.
Yes, sir.
Okay.
Forgive the intrusion. Mr. Shelton, this is Alita, your attorney, or Ms. Swallow, your attorney. Just for the court's benefit, Mr. Shelton is currently in the Denver metro area where he's going to be reunited with his dog here shortly. And then his plan is to enter detox with his dog. And entering with his dog ensures that he'll be able to go to the foundry with his dog. And so that's kind of what the waiting period is for.
Yeah, understood. And I had authorized his WebEx appearance here today, and so understood. I, for some reason, thought he was already in today, but I completely understand. And so I'm glad that you're doing that, Mr. Shelton, and I hope you can reunite with your dog and everything like that. And so, okay, why don't we try to get a new court date where we have Mr. Shelton appear over WebEx so that he can go into treatment and do what he needs to do. Would the parties be available on September 3rd at 1 o'clock p.m.?
Yes, sir.
Yes.
Okay, so it works for Mr. Shelton, it works for Ms. Swallow. Does it work for the Public Defender's Office?
Yes, Judge.
And then does it work for the prosecution?
It does, Your Honor.
Okay, then Mr. Shelton, we'll see you on September 3rd at 1 o'clock p.m.
Thank you.
sir.
All right, thank you. I can turn on the white noise if you want to talk
That's
to
okay.
him.
Could we call Mr. Davis's case?
Yeah, let's go ahead and call Mr. Davis. This is 25M2121, People's State of Colorado versus Lane Davis. Mr. Davis is present with counsel Ms. Spradlin. We've got Mr. Collinsworth with the prosecution. We're scheduled here today for status. Ms. Jones?
Ms. Spradlin advised she ran her docket this morning and his name did not pop up. As you're aware, it looks like she was just entered on the case. She's asking for a set over to Friday to address bond on Mr. Davis's case.
Yeah, the court should be able to accommodate that. Would the prosecution be available on Friday the 15th at 1 o'clock p.m.?
We can't address bond
Yes, Your Honor.
today
Okay.
because the DA has to be put on notice.
All right, well, we're going to come back on Friday at 1 o'clock p.m. Mr. Davis, my hope is that before then, Ms. Spradlin's going to be able to touch base with you and we can address the issue of bond on Friday and go from there. Okay?
Thank you, Judge.
All right, thank you. Oh, wait, the court is also going to call 25M2096. That's Mr. Davis's other case. That'll return on Friday as well at the same date and time. Okay. That's everything I have on my docket. Is that for you as well, Amanda? All right. Are there any questions or anything like that before we break? Okay. All right. Mr. Collinsworth?
Judge, so I just got word from Ms. Deere.
All services within 24 hours of your release. Comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim in action charged with committing. No driving without a valid driver's license or insurance. Next court date will be August 19th, 2025 at 8:30 a.m. and 5 a.m. Anything else from the people or defense?
Nothing.
Thank you. Deputies, who have next?
We have De La Rosa on the mobile unit, Your Honor.
De La Rosa, 25M1916. Good afternoon. Good to state your name for the record.
Angela De La Rosa?
Did you watch a video, read a piece of paper advising you of your rights?
Yes.
Do you have any questions regarding your rights?
No.
Okay. Have you had an opportunity to review the charges against you?
Yes.
Court did review the affidavit in support of warrantless arrest, did find probable cause. We'll start with people regarding bond and bond conditions.
The defendant's behavior with officers in this case is highly concerning to the people, especially because the officer requested a no contact order, which I don't see often. She has a high CPAT score and 5 FTAs and 3 failures to comply. So I think a higher cash bond of $500 is appropriate here. Additionally, although this charge in particular doesn't involve alcohol or drugs, the defendant was found at a bar by police and has a history of drug use. So I would be requesting monitored sobriety because I do believe that will help assure that she will not FTA her court appearances. We'd also request that MIPS be authorized.
From the defense.
Yes, Judge. First, I would say that I think that it's, again, the court's confined to the 4 corners of the affidavit. She was charged with nothing in regard to her behavior towards law enforcement or anyone else. This is a class 1 misdemeanor on unauthorized use of a motor vehicle. If the people were so concerned about her behavior towards officers, I would think that that would have warranted some sort of charge. Being that that is not charged, I think it's inappropriate to consider. As well, I'm going to ask that the court, if the court imposes standard supervised probation, that the court does not include drug or alcohol monitoring. Being found at a bar does not mean that she has any kind of drinking or alcohol problem, or that that would contribute to her non-appearance, or that it would contribute to any inability to comply with this court's orders. So I, again, think that that consideration, when it doesn't relate to any charge in the affidavit or what we're here for, is incredibly inappropriate. I'm going to ask for a co-signed personal recognizance bond. Ms. De La Rosa also has her entire immediate family here, has been in Colorado for the last 47 years, is working, and it has significant ties here. So I think that co-signed personal recognizance bond, only in light of the FTAs, would be appropriate in this case.
Thank you. Reviewing the bond application arguments from people in the defense as well as the affidavit, the court does note CPAT score of 4, overall score of 15, 5 failures to appear, 3 failures to comply. Taking everything in consideration, courts can set bond the amount of $100 cash only. Courts can order standard pretrial services. Court will authorize MIPS remain law-abiding, report probation and pretrial services within 24 hours of your release. Comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the actual charge of committing. No contact with the named victim in the affidavit with a 50-yard distance restriction. Next court date will be August 25th, 2025 at 1:30 p.m. in 5D. Anything else in the people or defense?
No, Your
Yes,
Honor.
can I set up a time to get my stuff from her apartment? Because that's where I was staying at, was at.
Ms. Marchek, are you requesting a civil standby?
Yes.
Perkins, do you have objection?
No.
Okay, court will authorize a civil standby. Okay. Thank you. Deputies, who we have next?
It's Todd, Your Honor.
Okay. Todd, 25M, 1921. Good afternoon. Could you state your name for the record?
Kenyatta Todd.
Did you watch a video, read a piece of paper advising of your rights?
Yes, sir.
Do you have any questions regarding your rights?
No, sir.
Have you had an opportunity to view the charges against you?
Like know what it is?
Have you had an opportunity to review the charges against you?
I believe so.
Okay. Court did review the affidavit and support a warrantless arrest, did find probable cause. Ms. Perkins, you seeing exception there, 16-4-113?
I believe the defendant's currently on bond for a felony out of Weld. I think that's an exception, is it?
I
getting that
believe it
wrong?
would only just be warrants,
Okay. Then
unless I'm mistaken. So,
I think our guidelines said something different, but if that's what you go by, that's cool.
well, I can double check. Fails to sufficiently identify himself, refuses to sign the PR, prevent imminent bodily harm, no ties to jurisdiction, previously failed to appear for trial, outstanding warrant. Okay. Any other recommendations on bond?
No, Your Honor.
Okay. Ms. Morchek, any additional record?
Just that per the administrative order, there is no exception. She shall receive a personal recognizance bond under the law.
The court's can set by the amount of $500 personal recognizance bond. The court's can order enhanced pretrial services. Court will authorize MIPS. remain law abiding, report to pretrial services within 24 hours of your release, report to probation as well. Comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against or tamper with any witness to or victim in action charged with committing. No contact with the named victim in the affidavit with the 50-yard distance restriction. Next court date will be August 25th, 2025 at 1:30 PM in 5D. Anything else on the people or defense?
No.
No, Your Honor.
Thank you.
Thank you.
Deputies who we have next?
We have Mr. Coolin on the mobile unit, Your Honor.
Okay.
Yes, good afternoon, Your Honor.
Good afternoon. Roland 25M 1922. Good afternoon. Could you state your name for the record?
Oh, James Coolin.
Did you watch a video or read a piece of paper advising you of your rights?
I have not, but I have seen before because I have a case pending before you. I have arraignment September 2nd on a similar charge.
Okay. Do you have any questions regarding your rights?
I don't have questions regarding my rights. I did want to say that in relation.
Well, Mr. Coolin, I always advise individuals to speak through their attorneys. Everything is recorded, could be used against you at a later date and time. Purpose of today is to determine bond and bond conditions, not guilt or innocence. With that
Okay.
said, you do have a right to speak on your own behalf, but I'll give you that opportunity after both attorneys have spoken, okay?
Okay.
All right. And have you had an opportunity to view the charges against you?
I believe so, yes.
Court did review the affidavit in support of warrantless arrest, did find probable cause, will start the people regarding bond and bond conditions.
Thank you. This defendant is currently under pretrial supervision for this exact same offense that occurred in March, where he had an open alcoholic beverage in his car and was charged with a DUI. He was ordered to submit to random UAs by pretrial, so it's concerning that he was still drinking while driving while being on UAs. And that in this case, he had cocaine and 3 bottles of vodka in the car, as well as a rifle. Of note, he was also convicted of prohibited use of a weapon here in Colorado and was charged with being reckless with a gun in 2019 and another alcohol-related offense in Kentucky. For that Kentucky case, the defendant has been a fugitive ever since. So the people would request a $500 cash bond, enhanced pretrial supervision. And since the defendant was submitting UAs with pretrial services and still was drinking and driving, we would request daily UAs rather than the recommended twice a week, random BAs, and no weapons or firearms. And we would also ask that he be prohibited from leaving the state due to him leaving the state in his Kentucky case.
Thank you. From the defense.
Yes, Judge, we're asking that you adopt what the bond commissioner agrees is an appropriate bond in this case for a $2,250 co-signed personal recognizance bond. We have no objection to the enhanced pretrial supervision. He has minimal criminal history and has been in Colorado for the last 52 years. He has employed here. He has family ties to the state here. And so for those reasons, I think the bond commissioner's recommendation is appropriate.
Being the bond application arguments from the people in the defense court, those notes that you passed score of 2, overall score of 8. Reading the affidavit as well. Court's going to set bond in the amount of $5,000 co-signed PR bond. Court's going to order enhanced pretrial services, no alcohol, no drugs, no marijuana without a valid prescription.
Hi, Walter.
Modern sobriety is directed by pretrial services, random. Well, pretrial, I just want to make sure the random UAs with ETGs, those go back, is it 3 days?
Is that me, Your Honor?
I'm
Pretrial?
not sure, Your Honor. Yes, I'm sorry. I'm not sure,
That's
Your
fine.
Honor.
Okay. I'm fairly certain that those go back a few days. So the court's going to order random UAs with ETG authorized, they'll monitor any use throughout the week. Report to pretrial services within 24 hours of your release, no weapons, obtain permission before leaving the state. Comply with the mandatory protection order that states you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the act you're charged with committing. No driving without a valid driver's license or insurance. Next court date will be September 2nd, 2025 at 1:30 PM in L1. Anything else to the people or defense?
No.
Nothing from the people.
Thank you. I see Denver on the line. We're going to go ahead and call the Denver matter.
Your Honor, Mr. Coolin had a question. I just have one thing to mention, sir. I understand that there was a firearm in the vehicle, but it's an heirloom. It doesn't even work. I had all my personal belongings in the truck.
Mr. Coolin, you're just incriminating yourself right now, okay? The bond's set, bond conditions are set. Okay.
Okay.
Ponce 25M550 from Denver. Good afternoon. Could you state your name for the record?
Salvador Ponce.
So I thought I stopped it at the end. I have a delay.
Okay.
And then I realized it wasn't at the end, and I played the end real quick. But okay. I don't know if we got into the next clip or not for a few seconds, but we're done for today. We did it. We made it through the end. Stupid cats ruining my live stream. Thank you so much for coming out, guys. I really appreciate it. I shall see you all again tomorrow. Well, I'm going to set up OJ. Yes, I'm going to set up OJ. So I'll see a couple of you in OJ. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her style is classy. She's always top shelf. Don't take my word. Come and see for yourself. Her cases are new with a twist or two. I really like them. I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcoming place. And so